Good evening. We have people still filtering in, but I'd like to welcome you to our second webinar. It's for mediation in cases of family violence, and Jennifer Davis is our guest presenter. Before we begin, I'd like to provide a land acknowledgement. So we acknowledge that our webinar is taking place on the unceded traditional lands of the Wolastoqey and Mi'kmaq people, governed by peace and friendship treaties. We thank the Indigenous people who have cared for our lands and celebrate the continued strength and spirit of the Wolastoqey and Mi'kmaq people. We commit to the ongoing work to make the promise of truth and reconciliation real in our communities, and this work will inform our discussion at this meeting and beyond. So this presentation is being provided by the Alliance of Centers for Domestic Violence, and particularly in supporting the survivors of family violence in family law. I have a few housekeeping points to provide, and those will be repeated in French by Jim Couture when I'm done. And you'll be able to understand that if you prefer to listen to the webinar in French, there is simultaneous translation that is being offered. So yeah, the first point at the bottom of your screen, you will see a globe icon where you can select your language of choice. We're using the webinar function of Zoom today. This means you are all automatically on mute and your cameras are off. We will be recording today's webinar up until the question and answer portion. Therefore, we will reserve all questions until the end of each presentation. If you have questions due to technical difficulties, please use the chat function located at the bottom of your screen. The chat is only visible to the hosts and panelists. Someone will try to help you. Questions for the presenter may be typed in the Q&A function of Zoom, and this is located at the bottom of your screen. Now, Jim will provide these same instructions in French.
Bonsoir tout le monde. La présentation d'aujourd'hui sera offerte en anglais. Cependant, nous avons prévu une traduction simultanée en français. Au bas de votre écran, vous verrez une icône en forme de globe où vous pouvez sélectionner la langue de votre choix. Vous pouvez également couper le son du haut-parleur d'origine. Nous utilisons aujourd'hui la fonction webinaire de Zoom. Cela signifie que vous êtes tous automatiquement mis en sourdine et que vos caméras sont éteintes. Nous enregistrerons le webinaire aujourd'hui jusqu'à la partie questions et réponses. Donc, nous réservons toutes les questions jusqu'à la fin de chaque présentation. Besoin de confirmer avec chaque présentateur à l'avance. Si vous avez des questions dues à des difficultés techniques, veuillez utiliser la fonction de chat située en bas de votre écran. Le chat n'est visible que par les hôtes et les panélistes. Quelqu'un va essayer de vous aider. Les questions pour la présentateur peuvent être saisies dans la fonction questions et réponses de Zoom. Celui-ci est situé en bas de votre écran. Passez une bonne réunion.
Thank you, Jim. So my name is L.A. Henry, and I'm the project manager for the Atlantic section of the Alliance for Supporting Survivors of Family Violence in Family Law. And with me is Carla O'Regan from St. Thomas University, who is the research lead on the Atlantic portion of the project. She's been working on a brief, but tonight we have Jen Davis with us, who is currently a family law lawyer and has an expertise in mediation. She was a labor mediator, a senior labor mediator for an earlier career prior to going to law school. So we feel very fortunate to have her in our community of practice and are very interested to hear her expertise regarding mediation, particularly in situations where family violence is a factor. Traditionally, it's been viewed that mediation is not appropriate when there's significant power imbalances between parties, but Jen Davis provides a hopeful overview of ways that mediation can be appropriately used to resolve matters and avoid having them to go through the trauma of court proceedings. So without further ado, I'll turn it over to her. And after her presentation, there'll be time for questions and answers. So please feel free to jot things down, or if you want to put things into chat, we'll read them off and allow her to address them after her presentation. Go ahead, Jen.
Suppose I have to take myself off mute. Good evening, everyone. Thank you very much for joining us. I know to join us on a chilly October evening, when there are lots of other things to be doing right now. It may be a difficult thing for you. However, we do have an exciting bit of lineup here tonight. I know that there has been a lot of discussion recently amongst our community of practice. So we have thought to put together this webinar to introduce, I guess, some of the concepts of mediation and how those can be used in cases with history of domestic violence. There are difficulties, I would say, in terms of going through any procedure, whether that be mediation or court procedures, or any other kind of dispute resolution. And this is a tool that we can use to bring parties closer together in terms of their resolution. But we'll talk about some of the difficulties that people have with the introduction of mediation into a case or parties, clients, where a history of domestic abuse has been present. I have to, there we go. So tonight,
Alors, ce soir,
we've gone over
on
some
a,
introductions
on
here
a
tonight.
fait,
This is just a brief overview of the webinar. Um, I would like to make a comment on audience participation. I do encourage you to use the chat function or in the Q&A for the end, but the chat function, certainly during the presentation, I am much more adept at providing presentations in person, and I tend to feed off of a little bit of the energy and the questions and the engagement of the audience itself. So I will give you my mea culpa admission that this is a little bit more difficult for me. It's a little bit more unknown, but I'm going to do what I can do for you, because I think the information that we have to share here this evening with you is something that is important to any practitioner, to any professional who is involved in family law. Not just lawyers, but all of those who are connected with that nexus of family law. The role of the panelists, we have our folks here. These are folks who are very much involved in the community of practice, and have been doing incredibly hard work behind the scenes. So any opportunity that you get to thank them for all of their organization for this evening, I would encourage you to do so. So this evening, we're going to talk a little bit about mediation generally first, and some points about the general. Sorry, I'm getting a buzz in my ear about the prevailing opinions, I guess, in the industry about the use of mediation with parties who have a history of domestic violence. Much of my report or my presentation here this evening was garnered from a report that was done in 2017 that identifies really great assessment criteria for a model of mediation. It speaks about the features of a mediation model that are assets to have, but they are not integral to the success of the running of the model. We will speak about some best practices that came as a result of that study, and discuss some of the competencies that you should be looking for in dispute resolution professionals as you're engaging them to work with the parties. We'll draw a couple of conclusions, and then we'll have a Q&A session. I do plan to leave as much time as possible for the Q&A session, because in previous webinars that we have put on, and also in our community of practice meetings, we have found that that's where a lot of the real value of the learning has come from, is hearing the perspectives of all of the other professionals that are involved in family law and involved in the types of scenarios that we're going to discuss this evening. So again, I'd encourage you to be as involved and participatory as you can through the chat function. And I do see the chats here. So as you comment or ask questions, they will come up on the screen here, and I'll try to address those and work them into the presentation that you're going to hear tonight. So I wanted to start tonight with a little bit of what mediation isn't. There are, the proponents of mediation, no matter what the situation, may tell you that it is a great quick fix for things. It's not. It's not a quick fix for long and hard and ingrained conflicts, especially when those relationships have been enduring and ongoing for so long that it is not something that is going to change a world in the run of an evening or a run of a session. It's not a happy, lovely, happy-go-lucky doing a jig and singing where everyone walks away happy with the results. There are lots of emotions. There are lots of very difficult decisions for the parties to make themselves. They may walk away. I mean, certainly the goal is for them to be satisfied with the results of the mediation itself. However, it's often not a very pleasant manner of getting there. Effective, yes, not necessarily pleasant. It's also not a victim's escape from other equally hard formal or court procedures. So the family lawyers who are in our audience here tonight, beware of recommending these kinds of alternative dispute resolution to victims who are just simply afraid of appearing in a court to testify, for example. In a family related case. So it's not, it should not be used to avoid what the particular difficulties or the barriers are with the other procedures that appear along the continuum or the spectrum of dispute resolution. It's also not a perpetrator's escape from justice. It's not an opportunity for them to avoid taking any responsibility. It's also not the place that responsibility for past actions, it may not be appropriate to be discussing that. And we'll talk about that in a little while when we talk about what the objectives of a mediation are. Certainly in a perfect world, a mediation would solve all problems and is the solution to all things. However, it's not. Mediation in these kinds of scenarios really has to have a very defined view and focus on what the deliverable is, what it is that we're trying to achieve. I would suggest that in the things that we're trying to resolve in family law, a mediation may not be the initial place to work on the relationship. That may be a longer term goal, or it may not be appropriate at all. In some cases, mediation might be the only place that the two parties actually ever come together, either face to face. It could be that they never ever come together. So again, we'll talk about all of the forms that mediation might be able to take. And it's not always safe. And that's why you really need a qualified and very, very competent dispute resolution professional to recognize and anticipate the safety issues, the safety concerns, not just from a procedural point of view, but the safety and the emotions that go along with that for each of the participants as well. It may, it will at some point, I said may in the slide, but it will at some point make victims and perpetrators feel even more vulnerable. And sometimes that's an indication that you're making progress. And in others, it's an indication that you need to slow things down and take a step back and let people adjust to the circumstances. It's also not a tool that should be used in every case of disputing families or disputing clients. There should be a very robust screening of clients and issues that are going to be put through a mediation model. It's not meant to replace other forms of dispute resolution, but it's rather there to complement them. So if you think of the legal issues that may be at play in a family law case, you could look at mediation as the attempt to resolve one piece of that or the whole thing. So it's not meant to replace those other forms of dispute resolution, including the formal procedures that we have in terms of court procedures and other kinds of dispute resolution, the other kinds of court procedures as well in terms of the criminal aspects that may be involved in, or that these participants may also be involved in. So what is mediation? Mediation is an entire toolbox of options, models, strategies, approaches to conflicts, or some parts of conflicts. It may be appropriate for one issue to go through the mediation model. However, the other issues may be deemed or assessed to not be appropriate for mediation. Either because of the subject matter or because of the power imbalances that may exist. So it's a real spectrum of interventions that have to be employed by an appropriately trained person, someone who is trauma informed, who is prepared, who is knowledgeable about not just dispute resolution, which was where I started, was solely on the dispute resolution side. But it does take someone knowledgeable in victims of abuse and the typology of and the levels of domestic abuse or violence that is occurring between the two parties or has occurred in the past between the two parties. That spectrum of interventions goes from very formal mediation kind of model where you have policies in place, you have the approaches, you have a real procedure to put the issues and the parties through. But it on the other side of that spectrum, it is it could be very simply the kind of conversation that you have with one of the participants. Mediation doesn't always take place in a mediation room. It takes place from the moment the dispute resolution professional is assigned the file and you pick up the phone to make the first call. All of those, all of the things that we will be speaking about tonight are things that the dispute resolution professional really needs to put some thought into and learn about the parties first before any sort of decisions can be made as to how the mediation will actually be conducted. So it's mediation then, I guess the words that I would use to describe it is that it's a system of assessing the circumstances, the power imbalances, the roots of the conflicts that are involved, and then designing a process around the individual's needs and interests for what the objective of mediation is, what they need out of the procedure or the model as a deliverable in order to be able to respect the agreements that they've made and carry those out. It's a facilitation of the relational and the informational exchanges between individuals. So in terms of the relational exchanges, it is facilitating those discussions in a way such that power imbalances cannot be used to coerce decisions out of another party. The informational exchanges take place in order to make sure that everybody is operating on the same basis of information. Now, these are absolute fixtures in any kind of mediation, but I find that they are absolutely integral to the process of mediating in cases of domestic violence as well. Generally, mediation is generally seen to be an option for parties to use voluntarily. That's what contributes to the largest probability of success, is that the parties have come to mediation voluntarily. But we know that that's not always going to be the case. In particular, the model that I'm going to tell you about, that this study happened upon in Australia, that is a mandatory model. So when I say that it's for parties to use voluntarily, even under the system of a mandatory mediation model, or a mandatory stream of mediation, the mediator, the dispute resolution professional, still needs to get the parties on board. So even though they may be ordered into that kind of a procedure, the dispute resolution professional has those tools in their toolbox of gaining their participation, their commitment, their engagement with the process. It's not enough just to simply say you're going to mediation on October 20th at 6:30 p.m. Show up at this place. There's a lot of preparation and groundwork that needs to go into this. Most importantly, being the dispute resolution professional's understanding of what the conflict is, what the circumstances in which that conflict plays out, and the concerns, the needs, the interests of the individual members who are participating in the mediation. So some of the prevailing beliefs about alternative dispute resolution. These are just kind of things that I've heard over the years about practicing ADR practitioners like myself. So the prevailing belief is that mediation just really isn't appropriate in cases of domestic violence for a number of reasons, including things like the power imbalances that may exist, the coercive control that may be exerted by one party over another. A victim should never be forced to participate in the presence of a perpetrator. This actually contains an assumption that mediation, that the way the mediation would be conducted has to be conducted face to face. And that's not in fact true. There are a number of different models and a number of different strategies and options that and adjustments or modifications that the mediator can make so that a victim is not forced to sort of confront their perpetrator. That may not be an appropriate point to come out of mediation. Some of the concerns also is the lack of an authority or an enforcement figure for the parties to ensure that they follow the agreements that they make. There's some concern that parties would go into a mediation just shut down a little bit. Please just let's get this over with as quickly as possible, as be as agreeable as possible so that they can come out with an agreement, get out of this process as quickly as possible. But then they end up with an agreement that is not going to be enforced by the two parties themselves, which will again make it difficult for all of the other professionals that are dealing with these clients and these individuals. It's also, I've heard that some victims very much want that day in court. They want to be able to speak about the wrongs that have been perpetrated against them, and the consequences that those have had in their lives, and have the opportunity to give give them a sense of justice by having, the authority figure of a court or some other formal decision maker making a decision for the parties themselves. Some people also believe that it removes a perpetrator's sense of consequences for their objectionable behavior. I would suggest that consequence for the objectionable behavior is more so the bailiwick of criminal courts, and that but the sense of consequence can also be felt in that we have had to come to these kinds of agreements, or we have these particular needs in how we communicate because of the perpetrator, because there is the victim does require some sense that the perpetrator has accepted responsibility in order to move forward. And again, we'll speak about that more so when we talk about the objectives of mediation. Others also feel that putting a perpetrator and a victim face to face in the room for mediation gives them an opportunity to continue the violence and abuse that they've experienced in their lives, especially if it is psychological abuse. Some parties can be on better or best behavior when there are others or strangers or witnesses to their behavior. But what I would say guards against this is all of the tools and the approaches that the mediator or the dispute resolution practitioner uses. It is their responsibility. It's their job as that facilitator to ensure that there's no opportunity to continue violence and abuse, that the ground rules are set up, that the process is set up such that it guards against those possibilities. I've also heard of some mediators that would say, I wouldn't touch that with a 10-foot pole, because when I go in there, I want an immediate resolution, and implementing their decisions or their agreements or managing their agreement afterwards. That's not my bailiwick. So as we'll hear about in a little while further on in the presentation, the mediation model necessarily has to implicate the mediator on a follow-up basis, on a longer term basis. While that may not happen in other kinds of mediations, it is absolutely integral to a successful mediation in cases involving domestic violence. Very good questions that people are asking as well. There are some talks about who are the trained mediators. I'll speak about a little bit about that at the end of this session, when we're talking a little bit about the competencies of mediators for such mediations. So we really have to pay attention to what the objective is of mediation. Mediation in the context of family law, the legal disputes that are being resolved, the purpose is not to resolve the root conflicts or the roots of those conflicts, or to resolve the trauma that may have occurred in people's lives that have made them be the people who they are today in the context of generational trauma. Is it to establish a good relationship between the parties? That may or may not be an objective of mediation. The objective of mediation may be, I would argue, is to come to the legal resolution that needs to be made because of the court procedure or the decisions that need to be made involving the family. But so a parenting plan, or the parties deciding on a division of assets in the case of a divorce mediation. The objectives of mediation, we really have to, through the process of mediation, through the agreements that the parties will reach, the mutual agreements that the parties will reach, it's about establishing their own expectations and the ground rules for the future relationship, if we want to call it that, or interactions, I guess, between the parties in the context of the agreement. It is not the be all and end all of how their relationship is to be governed, but it is very much important to have a very narrow focus for what those objectives are going to be. You can expand those objectives as you accomplish other objectives. For example, you may be able to work on the relationship later on once you have an established procedure for how the kids are going to be exchanged on a weekly basis or every couple of days. Communication maybe or improving communication may be an objective of it, but the agreements by the parties and mutual decisions by the parties will actually form the basis of the how they are going to improve that communication. So the objective of the mediation itself is not necessarily to improve the relationship or improve communication. The objective is going to be to come to these mutual understandings as to how that will govern our behaviors and govern our interactions in the future. In cases where the relationship is incredibly strained by instances of domestic abuse, it's even more important to make sure that the objective of the mediation is very, very narrowly defined, so that the parties and the mediator are not straying off into areas that are not the immediate needs or not the immediate concern of for the parties or for the other professionals who are working with the with the individuals. It's also about making those. Sorry, I'll restart this point. Oftentimes, for the family lawyers in the audience, you can probably agree that this happens, that parties go to courts, they get a decision or they have an agreement, and 3 weeks later or a month later, after they waited for 18 months for a court date, circumstances change and an amendment needs to be made. Someone moves to a different area. And rather than allowing the parties who have been involved in mediation before to simply address those on their own, if they can use the objectives, or sorry, the tools of mediation, use those mediation sessions to improve their understandings as to how their relationship will be impacted today, or the rules of the game, the rules of engagement between the parties, then that will assist being able to make amendments at some point later on when those circumstances require. This, as a mediator, they should be able to have an ongoing relationship. And that, I think, is what is the difference between family mediation and mediation in a lot of other contexts, including labor mediation, collective agreements, mediation between coworkers and things like that. The real implication of a mediator in cases of domestic violence, it will necessarily be a much longer term involvement for the mediator. And we'll explain why when we speak about the models here. So the report that I'm going to refer to was published in 2017. So it's about 3 or 4, almost 5 years old now, I suppose. It's called Mediation Models for Family Cases Involving Domestic Violence, a Jurisdictional Scan. And it was done here in Canada at the University of Victoria. And they reviewed different jurisdictions across Canada, provincial jurisdictions, as well as some of the models that exist in other countries, most notably Australia. And we'll speak a little bit about that one. So the research question that was trying to be answered in this jurisdictional scan is, what are effective family mediation models and best practices in dealing with differing levels and forms of domestic violence? Now, this report had some really interesting features come out of it, and I really wanted to go over some of those with you. So the research design came up with 5 different assessment criteria. And these are criteria that you would use to assess a mediation model or the appropriateness of a particular mediation model. Those 5 criteria are that the model has been applied, so in practical terms, has already been applied to cases with a history of domestic violence. So it has some sort of demonstrable application in these kinds of cases. The model places the emphasis on safety and autonomy. Now, on safety, the model necessarily involves a discussion amongst the participants and other professionals who are involved about the safety of the process itself, safety plans for the participants themselves. The social workers here in the audience tonight would be familiar with those working in transition homes, having a safety plan for someone trying to leave a situation of domestic violence. Often when we law professionals are getting engaged with clients of this nature, safety is the primary concern. Many victims will seek out a lawyer for advice, but where their concern actually is on the safety plan. The autonomy that the model must emphasize is the fact that there can be no coercion of the decisions. There is no use of the power imbalance or the wielding of the power imbalance that naturally is occurring between these two parties. There's no use of that in terms of coming to a resolution. No one is driving the process here except for the mediator. The mediator being the one to recognize and identify the issues that need to be resolved and to shepherd the parties through that discussion, and allow them to make their own mutual accords or mutual agreements. The models, the assessed models, the assessment criteria also deals with a screening tool for domestic violence. That the model itself has built into it a screening tool to determine the prevalence of domestic violence, the levels of it, whether it is coercive control, whether there is physical, emotional, mental abuse or violence occurring. It also has to recognize all those who are touched by the violence that is occurring in this family. Are there children involved? Are there elderly parents? Are there other dependents who require assistance, who require one or both of those participants in their lives in order for their best interest and their well-being? It also recognizes a successful mediation model for domestic violence also recognizes the importance of accommodating all family circumstances by making adjustments to the model itself. We all see the formation or the construction, sorry, I'm losing my words, how families are the structure of families, that some people may require the use of a support person. Others may require the involving other family members to ensure that excuse me. Sorry, I've lost my train of thought because I saw a dog on a screen with one of the participants. The model also has to require that the dispute resolution professional who is going to be involved in mediations with families with a history of domestic violence, that they've received training on domestic violence. They've received training recognizing and identifying the kinds and the types of domestic violence that are occurring, and strategies of how to deal with individuals who have either suffered domestic violence themselves or with the perpetrators of domestic violence. There are also 5 asset features. So these asset features of a mediation model for cases with a history of domestic abuse, these are things that don't necessarily speak to the success of the model, but they speak to, they certainly assist in there are options that assist to with the dealing of parties in crisis. So again, it has to be a model that is specifically designed for cases with a history of domestic violence. And again, that could be the implication or the involvement of other professionals, ensuring that there are counselors or social workers available to participants. Perhaps they are even actually involved in the mediation itself. Another asset is that the mediators are required to collaborate with those other professionals, and that they really run the process on a longer term basis. It's the mediator pulling in the resources that the parties require. And whether that is, accessing counseling for a particularly emotional issue that needs to be discussed in order to be resolved between the parties. It may require the mediator to collaborate and to consult with those other professionals as well. That poses some difficulties in terms of the professional associations, the regulatory bodies that we have, privacy, confidentiality, those kinds of things. A social worker can't necessarily pick up the phone and discuss the ins and outs of a particular client's case with a mediator unless they're part of that client's case plan. So there's a number of organizations and a number of case planning that needs to come together in order for all of the required professionals to be at the table to support the two parties who are going through this process. The model, a successful model, also requires a follow-up post-dispute resolution. A check-in 3 months later. Have there been any further instances of domestic violence? How has the agreement working out for you? Are there any difficulties? Are there any circumstances that have changed which require us to come back to the table to discuss it? Have you had any issues that have come up as you're trying to implement your agreements? And it also has to allow some modification to fit cultural needs. The example that I think of here is in the in Indigenous communities, the importance of elders to the community and to the process of dispute resolution between community members. The mediators who are not attuned to the cultural and to the cultural kinds of connections that individuals have to their communities, they're going to miss an awful lot of opportunities to draw in supports from the community, from others, and surround the participants with support. Generally, mediation takes place in a without prejudice, very safe, kind of controlled environment in that respect. The report itself also identified a number of best practices. So autonomy and safety measures. Again, the requiring the participants to be there voluntarily, or at least, even if it is a mandatory model, at least gaining their voluntary participation, their voluntary engagement with that process. And safety measures. There must be a safety plan for any successful mediation with a history of family violence. When do you stop a conversation? What are the triggers for each of the individuals who are involved? A mediator is going to have to be aware of all of those things and build into the process everything to ensure that the power balance cannot be upset through the process or through the discussion, and that both parties feel safe, in a safe environment, to speak their needs and speak their truths. The training for dispute resolution professionals is also in types of domestic violence, on how to manage individuals going through in the immediate sort of aftermaths of incidents of domestic violence, training for the dispute resolution professional in terms of how do you adjust or modify procedures or models to account for, say, the power imbalance, the coercive control. There's also a triage of services. So the more serious cases or the more serious risks that are posed by the situation, the circumstances that parties are under, receiving that much more urgent attention from the model itself, whether it be the organization that provides the mediation services, but some sort of a triage to recognize the unique circumstances in each of the cases that are coming up for mediation. Post-mediation follow-ups or post-agreement follow-ups, again, ensuring and rechecking with the parties that once they've left the session, the mediation room, that they haven't receded back into a former state in terms of their beliefs or their values. We want to keep that momentum going, and that seems to be successfully encouraged with a pretty stringent follow-up schedule for discussions to have, and that can be done in a very informal way. It can also be done very, very formally. To require participants to come back and actually check in face to face with the mediator. I've spoke to adapting mediation to reflect cultural needs. The only one that keeps coming to mind is the indigenous. If there is anyone in the audience who has any other sort of cultural ideas of the kinds of cultural needs that a mediator would have to be aware of and be attuned to, please leave them in the comments here, and we'll talk about it maybe when we get to the Q&A session. The revisiting the option for mediation at a later date. So even if your best screening tools and your best modifications and accommodations of the process, if at the end of the day, the dispute resolution professional comes to the conclusion that now is not an appropriate time. So if they say that now is not an appropriate time, those circumstances may change. They may change in days, weeks, months, or years. Having someone within that team of professionals that is wrapped around, ideally wrapped around individuals in these scenarios, having a social worker check in or revisit the option to return to mediation, or revisit the opportunity to participate in mediation when the circumstances involving the domestic violence have changed. Perhaps it is an individual who is just currently leaving an abusive situation. We all know that within the days and weeks and months of those events, that the opportunity and that the prevalence of violence is most heightened during those times. Perhaps that's not the best time to be forcing along a mediation process for these individuals. So it's making sure that even though today it's not appropriate, that there is still some procedure that will open the door for them at a later point in time. You don't want them leaving that kind of a discussion, learning that they're ineligible for mediation, thinking that they will always be ineligible for mediation according to the circumstances of their situation. That may change over time. So competencies for dispute resolution professionals, training on domestic violence generally, training on how to identify and classify power imbalances, and on the dispute resolution spectrum of how to account for those power imbalances in terms of the process, the setup or the design of the mediation itself. Some training on the modifications that a mediation that can be made to a mediation model, to not just to manage power imbalances, but to manage everything that we have spoken about here, to address individual differences, to address individual needs and interests as they're going through the mediation model. The continuous training, refreshing and competency development of the dispute resolution professional. If you look at the resume of a dispute resolution professional, and all of their training was from 20 years ago, and they have not necessarily been taking additional courses or professional development along the way, they're probably not the kind of mediator that you will want to use for these kinds of scenarios. We'll leave them to the labor world, I guess. For dispute resolution professionals, it's the practitioner kind of development that we're looking for. That is very favored over the theoretical or the academic kind of training. There, in my former life, having worked as a labor mediator, I can tell you that in most cases, mediators are born. They're not necessarily trained. There is something about the mediators or dispute resolutions professionals' ability to conceptualize the issues that are in front of them, to categorize and to classify, and to realize where there might be a loose string that might take us towards resolution. So this is not something that you could have someone with, the best Harvard Ivy League kind of education possible. But if they've not been out in the field and they have not dealt over and over and over again with different forms of the same problem, they're not necessarily going to be the ones that will contribute to success in cases of domestic violence. We're looking for in these cases, we are looking for practitioners, those who really walk the walk, who practice the things where those adjustments and modifications come quite naturally to someone. They have very innate abilities in that respect. The awareness and competency of consistently remaining neutral. This is an incredible difficult thing to do, because we all have our own biases. We all have our own ways of viewing the world. We all have had our own experiences, and when we're dealing with a topic like domestic violence, those biases will come out in your body language, in just your facial expressions, in how you deal with parties. And the parties will pick up on that. If you are trying to be neutral, the parties will pick up that you're trying to be neutral. The ability to recognize when the mediator, when the dispute resolution professional needs to take a step back and needs to sort of remove themselves back from that, center themselves back on what the objectives of mediation are, and then go back in and attack the problem with the perhaps that's not good language to use. Go back in and tackle the issue with all of the tools and making as many adjustments and modifications as come intuitively to them. That's the way most of that is going to happen. It's not necessarily something that you can plan for all in advance. There are a lot of on the ground moves that need to be made by the mediator in order to maintain that neutrality, to maintain the power balance that was put into the process by design. I noticed someone had a question about, what are some examples of how you would implement safety implement safety against power imbalances. For example, where safety is an issue in the context of physical violence, that you have a participant who angers very easily, they calm down not so quickly, that the anger quickly goes into rage, that and all of the steps of violence are occurring and accelerating. If you have those kinds of parties, maybe meeting face-to-face is not the kind of thing the mediator would want to be doing. So in order to manage the power imbalance that the perpetrator may use anger and rage, then that is the anger and rage. That's what we are removing. And if the only way to do that is to have the parties in 2 separate rooms, and the mediator doing shuttle mediation, where the mediator goes from one room to the other and communicates that way with the parties, that does contribute to a lot more open sharing, exchange, the informational and the relational exchanges, at least between the mediator and the participant themselves, which the mediator can then carry back to the other room and ensure that relational and informational exchange is happening, even though they're the go-between, they're the carrier of those messages. So that would be one example of how to deal with some of those power imbalances, and I'm sure we will get to lots of other examples too in the Q&A section, and so I'll save some more examples for that portion. So there also has to be an ability of the dispute resolution professional, and again, this isn't necessarily something that is trainable. It's something that, yes, you can receive training on, but your ability to use it successfully will really only develop over time and over usage. Is having that awareness and the ability to assess whether a victim or a perpetrator can confidently face the other side. Will they be able to express themselves effectively? Will they be able to have the discussions that they need to have? Can they identify what their interests are? Are they seeing things clearly enough? Are they far enough away from the last instance of domestic violence that they can see things clearly enough in order to express what those interests are? Also the perpetrator's level of acceptance of responsibility for the violence. This is generally one of the best indications as to whether or not a mediation model or a mediation approach can be successful. If there is some level of recognition of like, listen, I know I've been like this, and especially in cases of generational trauma, there's a lot of that there may be that recognition there, although a slight inability to control it or to cause change within one's own life. So these things a mediator has to be really, really aware of. And if the mediator assesses or determines that, one or the other party is not going to be able to effectively describe their circumstances or brainstorm some options or really express what it is that they need to express in mediation, then the mediator will have to find other ways to deal with that. And that could be, for example, meeting with the individual prior to any joint mediation sessions, if there will be joint mediation sessions, to have them to explore their interests with them in the absence of that fear factor or the thing that makes mediation so uncomfortable. So those are the best case sort of competencies that a dispute resolution professional has. The piece that I cannot underline enough is the practitioner development of the dispute resolution professional, and not necessarily the prestigiousness. Sorry, the lights have gone on in my off in my office. Not sort of the prestigiousness of the of the training that they have, or so it's very much, they need to be very experienced, they need to be very knowledgeable, have lots of training, and be able to think on their feet, and make adjustments and modifications, not only to the process but to their approach, the way they're approaching the parties, and the way they're drawing the parties out to one another. They've got to be able to make those adjustments very, very fast. I'm seeing a lot of questions, or not a lot of, but some questions come through here, and I really do want to save a lot of the discussion for the Q&A section, because I think that there's an opportunity for us to have a lot of really great exchanges on some of these. So let's look at the conclusion. So mediation is an effective tool for dispute resolution. Even in cases with history of domestic violence. It's going to depend on the circumstances. It's very much a case-by-case review, or a case-by-case assessment as to whether or not mediation is going to be appropriate in the circumstance. Most mediators are very skilled at doing that, because they will do it in every other aspect of mediating any other kind of dispute as well. But it does take some particular skills and abilities and attentions from the dispute resolution practitioner. It requires an approach that recognizes all of the factors that play into the dispute. So family circumstances, generational trauma, cultural factors, whether or not there are children involved, whether or not these two individuals will need to have some sort of a relationship at the end of this, whether it is or at the end of the mediation, are they going to have another 15 years of trying to co-parent or raising children? We have to be careful that we never use mediation in this context. In cases of domestic violence, it's not necessarily to be used to have the perpetrator admit their wrongs, or acquiring or getting the victim to forgive the perpetrator. While that may be an objective of some mediation at some point, for the purposes of family law mediation, of resolving the legal issues that would normally be put before a court, those do not need to involve any admission of wrongdoing, and it does not require the victim to forgive. So the state or the circumstances of the domestic violence can be left, because that's not the mediator's bailiwick to deal with. Those that's the role of other professionals that are wrapping around, in an ideal world, wrapping around the family to assist. It requires very much an experienced dispute resolution practitioner to assess whether or not it is going to, whether or not mediation could make a difference, and to pull out all of the stops, to make all of the adjustments to their mediation model to ensure the safety of the participants, both their psychological and their physical safety. We do, when I was a labor relations mediator, the thing that I always said when I showed up in a room was, I'm not going to leave you in any worse condition than I found you. And that also needs to be a central thought for mediators conducting mediation in cases of domestic violence. We should not be causing any further harm. We should not be leaving them in a worse position than we found them. And the idea is to put them on a path. While you may not see the benefits of those of being on that correct path immediately, those benefits are much more long-term in nature, and necessarily involves all those in the family, not just the two or the individuals who are involved in the domestic violence scenario. And I've said this a couple of times, the wraparound approach from all professionals. In mediations, I have not, while I have not spoken to the other professionals directly, what I have done is not scheduled a mediation, for example, until my clients both had confirmed to me that they had an appointment with their counselor, their therapist, or other mental health professional of some sort, and that mental health professional or whoever was available on the day of the mediation. I've conducted others where I've requested other family members be involved because they have been central to the two parties' lives and will continue to be central to the two parties' lives. Perhaps it could be, a young couple in the throes of separation, history of domestic violence, and it is, perhaps the mother or the father of one of the two participants. Do they each get to have a support person? Should there be any support people involved in these? These are all the kinds of questions that the dispute resolution, the mediator, will have to look at in order to create that wraparound approach. But on the very basic piece of it, to all of your clients, no matter if you are a social worker or a lawyer or other professional involved with clients as these, then you can also be making those connections with other professionals, even not to share information, but just simply to say, we have a mediation process that's coming up. I would like to have a social worker available or a counselor available. Perhaps it's arranging to have an elder or some other respected person who each of the parties will seek advice from, having them available. So making sure that all of those supports are in place for the parties. This is mediation in cases of domestic violence is probably should be probably one of the most open kinds of mediations that are being conducted, in the sense that we're not trying to hide the results from the other professionals who are assisting and also dealing with the outcomes of the circumstances of domestic violence that the parties are experiencing. So I know that I haven't necessarily given a here's the model for how to conduct mediation in cases of domestic violence. This is what you do. There is no such thing. As I mentioned right at the beginning of this presentation, mediation in these cases is a whole toolbox. It's not one tool, and it doesn't look the same for me as it would for you, for me as a dispute resolution professional, or for pathway mediation. They may have a completely different model that they use. So it's important, when you're looking at the kinds of professionals who can assist in the clients that you're working with, I'd encourage you to look back to the assessment criteria and the asset features that I spoke of. And those are the things that you'll be able to evaluate as to whether or not that professional, that dispute resolution professional, will be able to handle, I guess, the various facets of and aspects of mediation in cases of domestic violence. So think I'm going to leave it at this and have lots of time for questions and answers and discussion. And I thank all of you very much for your time and attendance here. I can't wait to get to some of these questions that are appearing on our screens here.
That's great. Thank you so much, Jen. That was a very informative presentation. And I really like that you kind of drew our attention to a principled approach, because it allows us to take those principles and then use them on other, with whatever models being used. They can help inform our critique of the model, or things we may wish to add to it. So I think that was an excellent way of approaching it. Now, I am also keenly excited about some of these questions. So the one I'm going to start with, and I'll get back to the cultural one, but so one participant has written, if the victims cannot see it or name it, how can mediators identify abuse in these situations, particularly with sophisticated or manipulative abusers? And I think just prior to that, there was the comment also from the same participant that coercive control indicates that many victims of abuse do not identify that this is occurring. So I kind of had that same thought, and was curious about how the mediator becomes aware of the dynamic in the relationship. I mean, clearly you would have some cases where there's already a police record, there's, recorded physical abuse, that, we already have it named, it's already kind of part of the fact mix. But in many cases where people are separating, there are various levels of power imbalances and coercive control, and they're not going to, for the person who's been experiencing the power against them, they're not even going to be aware, and they're not even perhaps going to have given themselves permission to name it that way, because that's part of the control, right? Like, you're not allowed to even think that or say that about the other person. So what's that like for you as a mediator when you're beginning a process with a couple? What are the flags that you look for?
It's hard to answer that, because I'm used to making those assessments and those judgments sort of on my feet with people before me. So having the opportunity to sort of reflect on that answer and not just intuitively do it is a little bit more difficult for me. I'll do my best though. So the main portion of the question, how can mediators identify it if the victims cannot see it or name it? So in terms of the training that the dispute resolution professional will come with, or should come with, to become a mediator, a good mediator anyway, you will have lots of training on recognizing when there are power plays involved. And again, it's, you may not even be able to put your finger on it. And that's where, again, this is a practitioner's field. There may be lots of things that are there's just not something that is sitting right here. There's not, I noticed that whenever he walks into the room, she's slinking into her chair and pushing back, and the body language changes. So you're correct. We're a participant where a victim does not necessarily see it or name it. The mediator or third parties who are around the individuals, they become quite attuned to the kinds of signals. One signal that I always listen for is, do they let the other speak? Are they constantly interrupting them? Do they get 2 words out of their mouth before there's a level of aggression? Is someone making really unreasonable assumptions or conclusions about someone's motivation for a particular statement? You didn't feed the cat. There's lots of So I'm trying to think this one on my feet as we, yeah, those are things that naturally occur in any kind of a mediation. The power plays that we're referring to, the interrupting, the dominating the conversation, the discounting, the blaming, discounting the opinion of the other person, the blaming the other person that, well, yeah, I did do this. I did this particular violent act, but you made me do it. You did this. And so is there the blame? Is there a shift of body language? Those are all, for me, indications of power plays. I like to think of, I sometimes tell stories, and I sometimes tell jokes, and sometimes my husband will look at me and go, no, it's not the right time for it. So yeah, you need to be able to have the soft skills of picking up on very subtle clues. Of if someone becomes suddenly quiet, there are a couple of reasons for that, and a good mediator should probably at some point very soon take a break and try to have a one-on-one. How you feeling? Is there anything that I can do to assist you feeling better about this, or to be more open and communicative in the mediation? Is there anything that would make you feel safer in doing that? Do you want to try maybe and practice on me? Do you want to give me the messages first, and maybe I can help you with that expression? So it's picking up those very subtle clues, and then trying to make modifications, adjustments, and accommodations in the process to deal with it as they come up. So I don't know if that.
Yeah, no, absolutely. That was
Okay.
an excellent answer. I do want to kind of get to the other questions, because I feel like we could discuss just that for a long time. But
Oh yeah.
so one person has asked whether mediators are allowed to educate survivors about coercive control or other forms of abuse that is not physical. Is that appropriate in the context of an ongoing mediation?
That's an excellent question. And I would say no. I would say no. It's not appropriate there, because what you're going to get is resistance. And if there isn't already an acceptance of, yeah, I probably crossed the line. Again, you've got to return to the objective of the mediation. What are we trying to achieve here? Are we trying to make a parenting plan, or are we trying to improve the relationship here? Are we trying to get someone to admit fault, or are we trying to take someone to get someone to accept blame? So let's go back to the objectives of what the mediation is. We all want people to take responsibility for their lives and their actions, but you've got to go back to whether or not it is appropriate. I would say ties back to what the objective of that particular mediation process is.
Yeah, that makes a lot of sense. The questions are coming hard and fast here. So this is a great one. How do you deal with minimization, blame, and normalization of abuse by perpetrators? Now you have somewhat addressed that already in terms of talking about the look for, but more specifically, yeah, can you just speak a little bit to how you would handle minimization or normalization?
Again, I got to go back to the objective. Always go back to your roadmap. Where are we starting, and where are we trying to end up? Yes, those are minimizing one's role, or the consequences, or the impact of their behavior. Again, I see those as cues, and someone minimizing their own role in that, I see that as a power play. That is There's no reason for us to be here. I've done nothing wrong. And, so I see that as a power play, and I'm going to make adjustments in that respect. I don't need someone to accept the blame or to accept I don't need participant A to accept what participant B is blaming them for. We need to find the focus in mediation is on the future. There may be a minimal discussion of the past for context, for background, for explanation, for examples. But the focus on the mediation and the deliverable for mediation is on the future. So if the minimizing of the violence is not seemingly causing any discomfort or harm to the other side and is still allowing the discussion to be fruitful and forward thinking, I would tend not to interfere with it unless it becomes problematic. Now, I would suggest that in most cases, it is going to be problematic. Now, my own personal feelings is no, it's never appropriate to minimize these kinds of things. But again, we got to go back to what the objective is. And the objective is not to have everyone mea culpa and say I can accept blame for this and you can accept blame for that. It's not the issue here. The issue that we're trying to resolve is who's going to pick up the kids on Friday evening and why and what are we going to do. So it's more of a keep forward focus, a future focus on the mediation rather. So minimizing necessarily has to implicate a past view of something. So I would probably try to very quickly get over the description of the past and say, okay, so that's how it was done then. How do you want it to look in the future? What is this going to look like the next time you do it?
Okay, so I'm going to combine two questions here, one in the chat and one in the Q&A, to sort of spearhead where I think they're trying to get at, which is that if you've got somebody who is engaged, deeply entrenched in the coercive control situation, and don't really even fully recognize it in themselves, is it possible that the mediator becomes a part of the coercive control process, manipulated by the abuser, and if it's future oriented, what sort of things could be put into place to guard against coercive control going forward? There's a comment about safety planning. So I'm kind of interpreting safety planning in like, yes, you map out this great parenting plan, but if there's an elephant in the room around coercive control, how is that not going to still continue to interfere with the plan going forward?
Yeah, and that's I believe where the mediator really has an obligation to explore with the parties the facts. Now, you may not want to do that in a two-party caucus, but you may want to do that as a sidebar with individual participants. You need the context of the whole dispute. You need, how have things been happening here? Is this a coercive control situation? Is this violent resistance? Is this, repetitive situational couple violence? Is what kinds of patterns are we dealing with here? And again, that's probably why I have stated probably over a dozen times throughout this presentation that the screening criteria, the screening of the levels and the typology of violence and of the abuse that is taking place, and it's the strength of the screening tool that will give the mediator, I guess, the first indication that this is the quality or the character of the relationship between these two individuals that you're dealing with. And we are going to have to be on guard, because, as we know, coercive control, that is one of the most dangerous of forms of abuse, because it's the one that is likely to continue, that is likely to increase in severity. That is, it's just generally more dangerous, and it's much more hidden as well. So the violent resistance and situational couple violence, those tend to be much more visible, whereas the coercive controlling typology of domestic violence is not necessarily apparent on the surface. And many victims would even describe themselves, their own participation in that relationship as, well, no, they did that because I'm the one that's done wrong. Mm-hmm. So along the same lines as the question, if they can't name it, how can the mediator? Much along those same lines, that the mediator will pick up on things. They may not have the entire understanding of what the situation is, but they should have that, and they must have that. And the way a successful model for dispute resolution in cases of domestic violence, that necessarily has to involve that screening tool. And it's through that screening tool that you'll know about these in advance, and the mediator will be able to plan for them, around their processes and their approaches and the tools that they're going to use. They'll be able to plan around the type of violence that is being suggested here. So I'll just give an example, where there's much coercive control. The mediator may wish to work with the parties on the ground rules of their communication, and communication outside of these ground rules is a no-go. And you build those ground rules in such a way that it attempts to exclude the kind of coercive controlling communications of that nature. So you deal with it up front. It's not something that can be dealt with very successfully if it just all of a sudden becomes apparent in mediation. It's something that the mediator and everybody going into that process should be aware of right up front.
That's awesome. We are running out of time. I did want to get to the earlier question about culturally informed mediation, and whether you have, I don't know if you have personal experience, but I'm thinking of our immigrant population, and folks that are coming from cultural and religious backgrounds that have very strong gendered roles, and also differing expectations of power and control within the relationship. And do you, have any suggestions for how to do mediation outside of a traditional Western kind of relationship?
Yeah, well, I can say I've not actually done any myself that beyond the involving Indigenous communities. But I would say that sorry, can you go back and ask that question again? I lost my train of thought.
Oh, just sort of mediation that takes into consideration
side of the Western. Yes. So when you mentioned gendered, different gender values or different from the Western sort of formulation, it's not our job to be imposing or trying to change cultural mores. It's not the mediator's role to be involved in that. If that is their lived reality, The mediator and the dispute resolution professional and all of the other professionals around do have to be culturally aware that, for example, if it involves a young daughter, and the prospects of, well, is she going to school, or are there various other options that the traditional family, having a very different cultural outlook, would like to look at. So yes, there are lots of ways of doing that. The feedback that I would give to that is that the mediator has to be very careful not to impose their own views or their own cultural values on how things work, or instructing parties that this is the way it has to happen because this is the way mediation goes. No, mediation and the mediator meet the parties where they are. And if that involves paying attention to the cultural and building into the process or building into the design for those particular parties, things that will assist or can be so that it won't be undermined by the cultural context that they live in. So yeah, I know I didn't give a very good answer on that one, but
that's okay. It's a tough one. And I think kind of the heart of that is not importing our values, still being mindful, of course, of abuse, but not bringing in our biases, I guess, about what relationship.
Yeah. And that the progress of mediation, that the success of the mediation is really defined by the parties themselves. It's not defined by, by me as a third party, by anybody sitting in the middle of a mediation, by anybody peripherally involved. The success is defined by the participants themselves. So if a mediator is not accounting for different cultural aspects or values, then it's just not going to produce success for the parties themselves.
Yeah, that's good. Okay, quickly now. Going to combine these ones. Who does risk assessment? Where do you find those tools? And how do you assess if mediation goals are empowering for survivors?
Yeah. How do you assess if they're empowering for survivors? That's based on the feedback of the survivor themselves. That's based on their participation, their feeling, their experience of the mediation. If let's face it, if it hasn't met their needs, or if they haven't been comfortable going through the process, then it very much has to be. Then you're not going to be coming out with an enduring solution at the end of it. Yeah.
So assessing and screening tools. Is there?
Yeah. So the report that I was referring to earlier is the author of it is Amanda Lichon, Lichon. And do we have the ability, Sheila, Carla, someone to forward a paper around to everyone?
I'll let maybe Sheila speak to that if she's available.
Sure, we can certainly do that. If you send that to me, Jen, I can distribute it.
Okay, wonderful. So I will give, I'll provide to Sheila to have it sent to all of the participants the jurisdictional scan that I used to formulate a lot of what we spoke about here tonight, and it actually has all of the details in here about the different kinds of models. The one from Australia is. I thought they had a name for it here, but it's the one from Australia that was the one that was the highest rated in terms of this research study, because it hit all of the assessment criteria and most of the asset features as well of appropriate models for dispute resolution for domestic violence cases.
That's a great resource to start with. Last question. And this is Jen and I were just opposite one another in a file in court, and this is really quite relevant because there's a presumption under the new Divorce Act that a shared 50-50 type of arrangement is preferable, which is quite a switch, at least in New Brunswick, from what the expectations had been. So what are your thoughts about domestic violence in regarding to best interest of the child and shared parenting? This is like
this is a tough one.
tiny question.
Yes, and without reference to any recent cases that we've worked on. So and by the way, everyone, we did resolve that that one. We ended up not having to do a trial. So I'm gonna gather my thoughts on that one. Can you repeat it just so I can have time to think?
The question was, how do you handle the issue of 50-50 considering
Right.
changes in the Divorce Act regarding DV as a factor for the best interest?
Right. I would say that that is a legal standard, that the Divorce Act also accounts for negotiated agreements by the parties. And in the absence of that, the best interests of the children. So I think we've all seen cases that have gone through court procedures, and they might have even had a tolerable relationship beforehand, but after the court procedure, they've listened to 5 days of each other saying the worst things that they could about the other. So, oh my goodness, it is definitely getting late at night. I keep losing my train of thought on this one. I'm so sorry. I lost my train of thought again.
And it's a question for a whole other webinar, so it's a big
Thank
one.
you.
But let's just say it's complicated.
Yeah, it's complicated in that it is the legal standard. It is the presumption that only applies where parties don't agree on their own, or where it's not ordered by the court. There are appropriate circumstances for it to be ordered by a judge. There are appropriate circumstances for it to be done by mediation. But it's important to note that the presumption, though, only applies in the absence of that judicial consideration or an agreement by the parties. So at the end of the day, it is the best interests of the children that will be first and foremost, and whether that be through the mediation process, because I believe that that's something that should also be underlined for the parties, is the best interest of the children. Yeah, it's a legal presumption that I don't feel should have a lot of bearing in terms of how the parties respond to that themselves. Although I do understand and have seen that that the parties will play with those presumptions and use power with those presumptions, and that was true with when there was no presumption of shared parenting, and it will be true under the presumption of shared parenting as well. That
answer. Yeah, thank you. Okay, I think we're over time, so I think that's going to be it. But I would like to, first of all, really thank Jen. That was a wonderful presentation. I think we've got a lot to take away from that. Thank the attendees. Thank you so much for your time and attention here. And remind you that in the chat, we have a link to the evaluation tool. If you don't mind, please take a moment and click on that. It'll be just a very quick form to check off your boxes in. And that's just helpful to our national project to be able to get feedback on the webinar. So thank you so much for attending, and thank you to Carla and Sheila and Jim for your administrative and professional help here. And we look forward to seeing you again, I hope, at our next webinar. So good night for now.
Thank you very much.